Well, hello there. Welcome to this week's edition of Wednesday Wisdom, and my name is JB Hilliard. And these are weekly video snippets just designed to answer questions you may have about estate planning or probate or other legal concerns that may be swirling around in your head. And for this week, I want to talk briefly about handwritten updates that you make to a will or on a will. So let's presume, because all of you have been watching these faithfully over the last few years, so you know you would have had your will already done by now. Let's just presume that. But let's say there are some updates you want to make, either a change in who you've named as the executor, or maybe some beneficiaries have changed, or maybe the assets that you're leaving have changed. And so what you want to make sure you don't do is just mark up your original copy of your will thinking, okay, I'm gonna, I want to change this. I want to change this person. I don't have this anymore, but I do have that, and make these handwritten notes and then never formally execute either an amendment to your original will, what's called a codicil, or to execute a brand new will. In most jurisdictions, and particularly I can speak for Georgia, when you handwrite on your will, that not only does not count as a new will because it hasn't been formally executed, which means that you haven't signed off on those changes and you haven't had the will witnessed properly, excuse me, then it doesn't count. And if you're marking up your original copy, that also invalidates that version of your will. So let's say you did a will 10 years ago. So the 2011 version you've marked up on the original. The 2021 version is your handwritten note. So in the court's eyes, you don't have a will. So it reverts back to the intestacy rules, which means that you pass away without a will, even though you actually have one that was updated in your mind and in your family's minds, but it doesn't count in the eyes of the court. So just make sure when you are doing updates that you're doing them the right way, that way is recognized in your particular jurisdiction or your particular state. In Georgia, you have to have a codicil or an amendment formally signed and witnessed and all of that. And if you have what's called a testamentary affidavit attached, then that part needs to be notarized. So the whole process is formalized. Just make sure that you're not under the presumption that, you made, in your mind, you made these updates, but in the state's mind and in the court's mind, you really haven't. You want to make sure you're doing it the right way. So with that said, that's all I have for this week. I do have some more Zoom hearing observations, but we'll talk about that later. As always, I thank you for watching, and we'll see you next time.